Good evening, ladies and gentlemen. You are welcome again to our Legotech Dialogues. And today, unlike our usual days, we have brought a panel. Yeah? We have brought a panel because what we are discussing today requires very fresh minds, because a fresh area of practice, really very, very fresh. And because the topic is heavy and very resourceful and very rich, I am joined with Naula Roda, very passionate about technology. Naula, you are welcome.
Thank you so much.
Roda is going to be moderating with, co-moderating with me. But also, most importantly, we have brought, I would say, the elephant, the lion in the jungle in the competition law practice in this country. None other than the popular Aziz Chitaka. Mr. Aziz Chitaka, you are welcome.
Thank you so much. I'm not popular, as
unfortunately, the world has blown the trumpet, so you can't adjust it any further. And we are also joined with none other than Priscilla Naiga, one of the few fintech experts we have in the country. I want to take the pleasure, first of all, to give you a brief bio of these guys. First, I want to confess these are very, very personal friends. And therefore, if I submit with a lot of passion, it is because they are really my friends. I'll start with Aziz. Aziz is one guy who requires no introduction if you have been following competition law in Africa. Aziz, for starters, holds a Bachelor of Laws from Makerere University. He equally holds a postgraduate diploma from the LDC. In short, he's an advocate of the High Court of Uganda. But I think for me, Aziz's differentiator for me is how he has cut his edge as a go-to competition lawyer in this country. Aziz is a member of Ad Legal International, a vehicle that has fought so many battles to ensure that companies, big techs, adhere to international standards. As is the only reason why your data now receives consent before being transferred. He led a team that took on Meta and WhatsApp, saying, wait a minute, for you to take Agre's data, you must have his consent. You don't say take Agre's data simply because he's on Facebook and you own both Facebook and WhatsApp, therefore you simply transfer the data. Aziz is also an ambassador for Oxford University in Uganda, representing them in the area of competition law and policy. Ladies and gentlemen, given an opportunity to discuss Aziz, we can discuss him up to morning because he has a number of landmark cases on his name, including the recent NBS split advertising, digital split advertising, where he has challenged, says, wait a minute. Yeah? So there are so many cases to his name, and in the interest of time, you will find his CV on our social media handles. Now, that takes me to the lady next to me, Priscilla Naiga. Priscilla Naiga is a legal associate with Diamond Advocates. And I must confess, all the fintechs I have learned has come from Priscilla Naiga. She's so passionate about fintechs. She holds a Bachelor of Laws from Makerere University. She holds a postgraduate diploma from the LDC. But also she holds a Master of Laws from Makerere University. Those who have been following Priscilla, she has published a lot on fintechs and digital law and competition law. She's so passionate about the digital part of things. When you are reading her article, if she's talking about banking, trust me, she'll be talking about the digital banking part of it. She'll be talking about virtual assets. That is Priscilla for you. If you are looking for the right lawyer to advise you on the money that left your bank account and they are saying, but you withdrew the money using your app, the right person to go to is Priscilla Naiga. And I think for me, this is a very, very beautiful day. And when I got to learn that these two people are, holding big conferences, I said I would jump on this opportunity so that they come and tell us about these big conferences. And before I bring them on board, I also want to introduce Naula Roda. Naula Roda holds a Bachelor's of Laws from Kampala International University. But also she has done a lot of work in the digital space. Yeah. Not long ago, she was running a TikTok account called Daddy's Lawyer. But in between there, I think the mother became jealous. They said, so you're only the Daddy's Lawyer. She changed it. What's the name of the TikTok account now?
It's Legal Tune.
It's now Legal Tune. The power of the mother. The thing moved from Daddy's Lawyer to your Legal Tune. So, ladies and gentlemen, I want to take the pleasure to welcome you. Priscilla, you're welcome to Legal Tech Dialogues.
Mr. Galandi.
Mr. Ziz, you're welcome to Legal Tech Dialogues.
Thank you so much. It's a privilege to be on this platform. And I thank Diamond Advocates together with the sister entity, Legal Tech Dialogues.
Thank you very, very much. Now, for starters, you guys are organizing big, big things. I was receiving calls and I also had no answers. Tony, please, you need to call these people because we are hearing big tech, who is accountable, big data, who is accountable. And then we're also hearing fintech training. I mean, for starters, I think I will start with you, Aziz. What's this summit about? What is it? Why should we come for it?
Well, the Big Tech Accountability Summit, as the name rhymes, is all about holding Big Tech accountable. But it looks at the African perspective, not only Uganda. Why? Because we have seen the evolution of Big Tech accountability in Africa, starting all the way from Nigeria. Then we had a case in Uganda. We've had cases in South Africa and Kenya. So having a conversation which is purely centered on national dialogue wouldn't make sense. But we thought it wise to push the conversation forward because this is the first of its kind. And we want to see the different perspectives from the regulators, the practitioners, and the civil society on issues concerning big tech accountability. So the issue about big tech accountability, it's not about only the big tech, but we are trying to push forward conversations which have a close link between data protection and competition. Because when you look at the evolution of the notion about big tech accountability all over the world, where it started from the EU, we've seen lots of cases in Brazil. The issue about competition vis-a-vis data privacy is what is most contested about. Then the latest that we are seeing is the emergence of AI and also the kinds of the different negative effects that come along with it. Now, the questions which we are asking are, much as these big tech have a lot of influence, they have a lot of power, they have a huge playbook, should we just let them go because they have endless pockets and so on? Now, for Africa, as Africa, we need to push back. We still have so many challenges. We have laws which are quite sketchy. We have laws which are fragmented. So we need to ask ourselves valid questions before we even think about that. You know, we've seen TikTok being fined in the EU. Now we rush straight to COMESA. Now, yes, COMESA might handle the case, but there are certain questions that we need to ask ourselves. So we need to push the conversation forward. The aim of the summit is to share the different perspectives. We know we have seen the different challenges, even in countries that we have seen or we are trying to benchmark from. For example, Nigeria. Nigeria came up with a precedent whereby it penalized Meta. Then all of a sudden we saw Nigeria entering into a consent, which consent thereafter information came out that they had even waived the penalty. Now, this was a conversation which came about during the time that we had started the organization of the summit. Now, one would think that, why are you holding a summit? Yet even the very, very benchmarking area that, you know, the country, the regulator that you're trying to benchmark from has been seen to be compromised by the big tech. But the questions are so many, and they all have answers. So the issue about the summit, we seek to have these questions answered so that we can see how we can move forward with the conversation.
Wow. Wow, wow, wow. So you are not shutting up. You know, before, when it comes to a summit is a huge thing. My lame language. So a summit is big, a summit is huge. Are we expecting some big names? And if there are these big names, would you want to pop up some?
Yes, of course. We've tried to look out for the key personalities which have been at the forefront of pushing the conversation for big tech accountability forward, both practitioners and regulators. We have Mr. Olomide Babalola from Nigeria. He has led most of the cases against Meta and Google in line with data privacy. Then we also have a regulator, Mr. Babatunde Irukera, who was the person behind the penalization of Meta in the decision that we saw by FCCP. Then we've also collected a number of speakers from the EU. You know, someone might ask why using whites, yet this is an African conversation. Yeah. Well, the rationale behind that is that we need people who have litigated, people who have debated laws and policy in the EU, because everything that we are seeing right now, even the laws that we are having in Africa, are all benchmarked from the EU. So if we are to say that we are litigating cases against Meta closing AI chatbots, we know that, yes, the parties which might be behind the action might understand the concepts, but now the issue shifts to the regulator. Will they be able to articulate the issues? Because even the EU itself suffers with, trying to regulate these. So we've picked personalities which have handled cases at EU level, and also those who have litigated and defended big tech. So we want the perspectives to be cut-crossing, that the Africans can have their perspectives, but then we bring in the EU perspective that this is where we started, and we believe that you're at this certain level, this is what you're supposed to do.
Wow. That is so powerful. So Ziz has decided to bring the world to Uganda, to Kampala. So ladies and gentlemen, this is an eye-opener for the conversation that is going to be coming through at the big summit. And as Lego Tech Dialogues, we felt it prudent that we give you this opportunity to get this information out there. So you need to look out for AdLego, I think their website. Aziz will be telling us how would we register, what do we require when we get back to that. And that takes me to Priscilla. Priscilla Naiga, you are welcome.
Thank you so much, Mr. Galandi.
You are organizing a fintech training. For starters, why do you think this training is important?
That's a very good question. So why is this training important? We are seeing a regulatory shift where the laws are going from theory to enforcement. And I'll talk about the history of competition law later on in the conversation, but for purposes of this question, we are seeing so many cases coming up. We had COMESA investigating Meta. We are having regulators convening in Kenya. In June, we had a conference on competition law. And then this week, Nigeria, the Nigerian Competition Authority, informed the public that it will be investigating certain market dominance allegations against certain AI platforms. So what does this mean for us as Ugandans? It means that these trends are going to catch up with us. Eventually, we need to equip ourselves with the compliance knowledge. So what is the purpose of this training? To equip fintech service providers with compliance knowledge. That is what we are doing with this training. And we shall be discussing the fundamentals of competition law. We shall be looking at network effects. We shall be looking at interoperability and all the market characteristics of fintechs and how they relate to competition law. And sitting here in this podcast today, I am reminded of John the Baptist's words where he talked about the person coming after him being so big that he does not feel worthy to untie his sandals. So I feel the same way about this training, and I will caution myself as I speak to not touch on the issues that our very distinguished panelists will talk about tomorrow. We have a very good lineup of trainers. We have Dr. Vela Kedogo Kwigiru from the Technical University of Munich. She's a postdoctoral researcher. We have Dr. Anthea Pawelo. She's a policy specialist from the AFI. We have Dr. Ryan Hawthorne from Akasha Economics. He's an economist. And then we have Mr. Raphael Mburu from the Kenya Competition Authority. So I will not touch on so many issues because the people who are going to speak after me tomorrow are much, much better positioned to speak on the competition issues in the fintech service economy.
Wow, wow, wow. Trust Priscilla. He says, for I baptize you with water, but there is one who is going to come and baptize you with the Holy Spirit. I love that. So you excite us about this competition law compliance and training. First of all, to our listeners, I'm sure Rhoda wants badly to ask you very serious questions. But before we get down to Rhoda, I would want you to tell our listeners, number one, where do we find the link? Number two, do we need to pay? And if so, how much? Number three, what time does the training start? And I will also pose that question later to Aziz along the way. But first, take us that line.
Thank you so much. So my boss, Mr. Galandi, always talks about a principle called democratization of knowledge. This is a very virgin area. And as Diamond advocates, being passionate about fintech law, we decided to give back to the community and have our first ever fintech training, compliance training. We opened it up. It is free of charge. We have sent out the Zoom links to all our social media platforms. If you go to our LinkedIn page, you'll see the Zoom webinar link. You can also reach out personally to info@diamondadvocates.com. We shall be live on X, formerly Twitter. We shall be live on YouTube. We shall be live on LinkedIn. And we shall also have participants on the official webinar.
Wow.
The training will also start at 8 a.m. So we look forward to the people that are going to attend, and please do not miss it, because fintech compliance is going to be a very serious compliance issue in the near future. That is our prediction as Diamond Advocates. So for us, what we are doing is we are equipping the community with compliance skills before the challenges arise. It is always better to equip yourself before the problem comes up. That is what we are doing with this training.
Wow. I think for me, in her submissions, I pick one line. Prevention is better than cure.
Exactly.
Compliance, are you an innovator? Are you a bank? Are you a telecom company? Are you a lawyer who is advising fintechs? You do not need to miss this training because it is important. The last line about the boss and so on, ignore it. She's asking for salary increment. Don't fall for the trap. And then I will take down to Aziz. When is this big tech summit?
Well, the summit is happening this month, July 30th and 31st, and we've organized it in such a way that the first day, which is 30th, we'll have discussions on data privacy and protection, and day 2 will cover aspects to do with competition. Yes.
Good. Do I need to sell my goat? And if so, how many goats do I need to sell?
You don't need to sell so many goats. Yes. The fee is friendly, 200,000 for 200,000 Ugandan shillings for online attendance, and then 500,000 for physical attendance. But this is only subject to the Ugandan jurisdiction. For countries all over Africa, they will be getting the summit live for free for purposes of the different MOUs that we've signed with regulators and the different partners.
Yeah, Trust Aziz is giving back to the community. Trust me, some of these conferences, when we move out of this place, we pay. They want to take our lungs out to pay just to attend a conference. 200,000 is a cafe javas for 4 people. So sacrifice that and be able to attend online. And thank you. I think now I will roll down over to my co-moderator, Rhoda. I'm sure you're itching with so many questions for Priscilla. Please shoot.
Thank you so much. Actually, according to what Priscilla said, she defined out that competition law is going to become more serious in Uganda here. Our dear listeners would love to know that in 2024, the Competition Act came into force, but is this Competition Act really in enforcement, or the fintech companies really need to be given time so that the regulators come in to start investigating such companies, or they should really be scrutinized of their actions?
Okay. So I think that question speaks to whether or not the law has moved from theory to practical enforcement. And my question is, we are experiencing a shift, like the examples I gave of Nigeria, and even in Uganda here, we've seen COMESA starting to investigate AI, meta platforms. So yes, there is a law in place, and with time, we are going to experience a shift. And the reason why we are gathered here today is to let the audience know that you can still acquire the knowledge to know how you could comply with this law before the enforcement catches up with you. So yes, there is a law, it is enforceable, and we are realizing a shift from the theory, because when people hear about competition law and the Competition Act, some people are always thinking this is a very new law and it's not possible that people are ready for compliance. But I'll make an observation. I think there is awareness of competition issues. And I say so because when you look at our register of participants for tomorrow's training, we have over 311 registered participants now. What does that speak to? It speaks to the fact that people are aware. However, compliance knowledge is the gap. People do not know, how do I comply? They know there are implications of certain business choices. However, how do we comply? How do we conduct our business in such a way that we are not promoting predatory practices in business? Yes, thank you.
Thank you so much for that beautiful insight.
Wow. I think for me, you bring out one key thing. Number one, ladies and gentlemen, reshare the link. I think there's a new link that has been set out. The first one got issues. And I think Aziz is trying to share the same. Please, Aziz, go ahead and share, because I think we have got a little bit of a glitch. But I think back to Aziz. For starters, you pose a question, big data, accountability, in a common man's language, because these are very technical terms. When you say accountability, when you say big data, if I'm speaking to a year one student of Makerere University, if I am speaking to my grandmother deep in the village, could you just break down, what do you mean by accountability? What do you mean by big data? I mean, in the layman, so that we are able to understand what this summit is all about.
For a layman's understanding of these issues, I do know that most of us here and those online have heard what happened so many years ago when oil was the biggest driver of the different economies. Then there was also a time when tobacco was the same. Now, when we talk about big tech, it's the same thing, because in the past we had big oil, we had big tobacco, and now we are having big tech. Why? Because right now we are seeing that the different big tech companies that came up do have a lot of influence and a lot of money to influence the law, to influence politics, to influence a lot of things. But the difference between big tech and big oil or big tobacco is that the other ones were so much hinged onto issues which were commercial in nature. Yes, big tech also has the different commercial elements with it, but it's unique in such a way that it cuts across different sectors. And therefore, that means that they do have a certain kind of playbook which they use to influence a lot of things, with the law inclusive. For example, even just by the arguments that they make in the different investigations. For example, they can say that we are okay with extracting your data from whichever jurisdiction you are, because we are compliant with GDPR, where we are stationed. But that raises so many questions that for them, they be having a strategy. They know that if you hold them accountable, this is what they are going to do next, because they have endless pockets and resources. We saw what happened in Nigeria. Then just this year, and even months before we got the decision from the EU, whereby Meta was penalized for the information concerning children. The same Meta comes to Africa and says that, oh, in Africa, Nigeria has the regulator who is very serious about holding big tech accountable. So what we are going to do is that let's come up with an MOU to support them with protecting children online. Because they have realized that, yes, much as Nigeria is the central place of the benchmark, so let's give them money. You get? So such things, there is a way they manipulate how laws are shaped. So the issue about big tech accountability, it's not about the big tech alone, but the conversations carry forward even to smaller digital markets like self-border. Because Meta, Google started off like how we are seeing these small startups, yeah. Even the fintechs. Yeah. But with time, they grew. Because right now we can see that maybe self-border might be having like one data center, but it will reach at a time when it has thousands. Even some in the deserts, some floating on the sea and so on. So these issues that we are talking about, the big tech issues, are the same issues which cut across to the issues that will be discussed tomorrow. So the issue about big tech, big data, they started as small entities, but now the notion that they are big is that we are trying to fit them into the terminologies that are always used for the different kinds of markets that emerge, like oil and tobacco.
Wow. I think for me, my take home, I think that writes back to Priscilla, which is about compliance and preparation. That what they say in Luganda and Echija Simuntu. So better be prepared. So I think you write very serious conversations down there. Now I think I will run back to Rhoda. Rhoda, you seem to be itching with a question, and I can see you pointing your eyes at Priscilla. Please, the floor is yours.
Thank you so much. Priscilla, my question is, for purposes of Uganda, we have many small fintech companies, but our competition act, should it really regulate the competition between the small growing fintech companies in Uganda compared to that of those big fintech companies, or it should let them compete fairly with those big fintech companies?
Thank you so much, Rhoda. So I'm going to answer that question, but I'm hoping that down the conversation, as the conversation advances, I'm given a chance to go back and explain, or I could just start by explaining the history of competition law, because I've actually remembered when we put out the announcement for this dialogue, I had colleagues asking me, what is competition law and what does fintech have to do with it anyway?
Oh, yeah.
So I think it is fair for us to take a step back and explain to our audience in the simplest terms possible what is competition law and how does it apply to fintechs, because we could sit here and discuss all this and yet we have an audience that we need to do justice to, like I said, democratization of knowledge. So you trace competition law back to the 19th century Northern America, where we had what we call antitrust law. So large corporations would come up, enter a legal arrangement where they form a trust, and in that trust, they could make decisions as to how they conduct their business. So, for example, an oil company could enter a legal arrangement with all other oil companies. They come up with a trust, and in that trust, they make decisions. How do we price our products? How do we market them? How do we supply them to the people? And one would ask, what is wrong with that kind of arrangement? So imagine a scenario where you stay here in Makere Chikoni. There are border riders, and these border riders enter into an arrangement to have an association. And in that association, they agree that for whoever is coming from Makere to go to Kampala, maybe City Square, we are going to charge 20,000 shillings. It doesn't matter whether the person is stationed there at the main gate, whether they are stationed here at Zuena Cakes. Yes, it's going to be 20,000. So what is the challenge with that? The challenge with that is that as a consumer, you have this illusion that I have a choice. I can leave this stage and go to the other stage. I can choose any border person I want. But however, that choice is an illusion. You actually do not have a choice, because whichever border you choose, you're still going to pay 20,000 shillings. Yes. So, and there is a family called Rockefeller. Rockefeller at the time was a leading oil businessman who came up with a trust. And in that trust, he entered arrangements with other oil companies so they could fix prices. And the effect of that is that even when it comes to the quality of your products, there is no competition because you're all producing a product at the same price. So meaning you have locked out all the other competitors. So I would like now to bring it back to fintechs. how do fintechs come into this conversation? It's a two-sided conversation. Yeah. We have fintechs as market disruptors, okay, and fintechs as market players. So I'll start with fintechs as market disruptors. We have traditional banking, and we know in traditional banking, there are formal processes of opening an account. You have to have some kind of documentation and so many other things. So when fintechs joined the market, especially when we look here in Uganda, fintechs joined the market. They offered accessible products. Turnaround time was very quick, and they were personalizing customer service. So I'll give an example of mobile money. Yeah. At the time when mobile money came, you see how it caught fire. Yeah. People were willing to buy into this because it was not like the traditional banking practice where you have to produce identification documents, you have to produce forms, give an address. We know that Uganda does not have a proper addressing system. I could tell you I stay in Makerere when I'm just there for 1 year. So when it comes to these new products that fintechs brought, you find that even the onboarding process was very fast. Yeah. So what did that bring about? It brought about a market disruption. Yeah. We had people going away from traditional banking and actually picking interest in these fintech products. So what does competition law have to do with that? Competition law protects that disruption. Competition law is protecting market disruptors. It is giving a fair chance to some small players to come into the market and compete with bigger players. So what is the other side of this conversation? The other side is fintechs as market players. So you could be a market disruptor and you could also be a market player, either dominant or not dominant, but the law applies to you and it scrutinizes your practices. So that is what fintech has to do with competition law. Like I said, the panelists that are going to take us through these conversations tomorrow are much more positioned to speak on some of these issues. I am just here to preach the gospel. Wow. Of those panelists. And
so, Priscilla, you seem to be keeping lots of cards in the chest, and I will not push that. Are you a disruptor? Are you an innovator? Are you a legal advisor? Are you a dominant partner? Dominant party? I think you need this conversation. Priscilla tells us she has set up a lineup of very experienced and very grounded people in this area. So
I had not finished Rhoda's question. I'm so sorry. I just thought it was good to take us back, but I'm going to conclude by answering Rhoda's question. So she was asking, is the law meant to protect smaller players from larger players, or is it meant to protect, or is it because it speaks to the two sides that I was talking about, because Rhoda is asking, should it protect or should it scrutinize? Now, at any one point, you could either be a disruptor or a big player. Now, the thing about fintechs is you could consider yourself a small player in the fintech ecosystem. But for whatever reason, whatever business practices you're conducting, you could actually find that you are abusing your dominance in that narrow sector that you are operating in. So it's the question is not whether or not you are big. The question is, how are you using this, even the small power that you already have? Because you could be a small fintech with your very small power or dominance, and it could have an impact. So the question is about how are you utilizing the power that you already have. So the law is meant to do both, to protect and to scrutinize. Thank you.
Wow. Very powerful conversations, ladies and gentlemen. My name is Tony Chire Galandi, and today we are joined with my co-host, Rhoda Nawola, and these distinguished, resourceful people. Mr. Aziz Kitaka, the He's a member of AdLego and a distinguished competition lawyer in Africa, so to say. And Priscilla Naiga, fintech expert. She has advised on mergers and acquisitions. Thank you. And I think I want to jump down to Aziz. Aziz, not long ago, your organization took on Meta, WhatsApp, and you decided to push this under public interest litigation. To a lawyer who has just left law school, who is looking for money, he's asking himself, saying, "Uno musajja yabachi." Why the level of of a public interest litigation approach? Fetuagala sent. So why the approach? Why overall approach? Why to take a public interest litigation approach in matters of this nature?
Thank you so much, Tony. In response to that question, there are so many issues which are underlying the reason why we took up Meta, and one of which is that what we are trying to grapple with as Africa, what the rest of the world is trying to grapple with, is the regulation of digital competition, kind of, because we are so much used to the traditional competition. And I'm so happy that Diamond Advocates is also spearheading this and pushing forward the issues concerning digital competition. Now, to the question, the evolution of digital competition. Let me start from there, and then I point you to the reason why we pushed the complaint. Now, digital competition in Africa, I would say, and even its regulation, it's new. Yeah. Because even for the major regulators, for example, COMESA, Competition Commission, where we filed the complaint, they have just come up with new regulations which have a provision which regulates digital markets. Yeah. Now, at the same time, we are also seeing developments by the AfriCITA, whereby they came up with a competition protocol, which also has provisions to do with regulation of gatekeepers, which is typically the digital markets. Now, one might ask, if I'm to challenge anyone, is there any investigation that has ever sufficed in Africa in regards to digital markets? None. And the beauty about this complaint is that it's not only in Africa, but world over, we are seeing AI markets emerging. Yeah. Now, this issue is so much pertinent for the regulators and the practitioners, because these markets are growing. Now, for us, our aim was to should I say, fuel up the kind of enforcement.
Light the match.
Light the match. Yeah. Because it was the first of its kind on the continent, and I'm so happy to see that COMESA has picked it up. And just next week, on Tuesday, the hearings for the Ugandan jurisdiction will be kicking off at Minister of Trade. Now, they are also so much interested in this because it's their new baby. You know, it's the benchmark that they are going to use when they are trying to decide most of the cases which are going to arise. And you know, I would say that COMESA is the gold standard regulator for competition on the entire continent. Really? So yes, true. Yeah. And them taking on this complaint means that whichever outcome the complaint is going to bring will be a benchmark for the entire continent. So ours wasn't about money, but it was about lighting up the match, like you've said. And because this creates business for firms. Yeah. For example, Bowmans represents Meta on the entire continent. Yeah. So they need to be busy, you know. They need to see that the regulator lands, benchmarks, and does a lot of things together with the different law firms which we are seeing, which are trying to represent the different AI chatbots and AI companies around the continent. So it's about coming up with a practice. We also want to reach at a level where we are seeing that Diamond Advocates has handled different cases on behalf of different digital kind of companies, because that's where you get money, that's where the practice is shaped, that's where civil society picks interest. So the issue about money is that, like how our minister says, money
Is coming.
money is coming. So our issue is not that we needed money
Yeah.
right away,
Yeah,
but
yeah,
we do
yeah.
know that in time, in future, soon money will come. And the main issue about the complaint was to start the conversation, to challenge the regulators, and to also prove around to the rest of the world that even Africa can push back to big tech big tech abuse of dominancy, and also to light up the laws that, for example, the commercial competition regulations that we have.
Wow. Aziz speaks like some writer Chikeuke, who says that he who plants a muvule tree or mahogany does not plant it for himself. He plants it for the generations to come. So it says money is going to come. Money is coming for the law firms. And they can only come if there are checks and balances. It can only come when people like Priscilla, when people like Aziz are saying, hey, wait a minute. Can you be able to observe basic standards? And I think before I shoot down to Rhoda, I just want you to pinch this down because it's linked to what you have just told us. You were at the forefront of filing this suit, this complaint, I would say, of Meta, against the Ugandan, to the Ugandan office, to COMESA, and we had the ruling. But then, when you look at this ruling and juxtapose it with the ruling in other jurisdictions, the fines, you know very well that the EU fined Meta in hundreds of millions of dollars. I don't remember the exact figure, but I think it was over 100 million US dollars. The US, still, on taking data without consent, they fined still Meta a huge, I think it was Apple still, a huge amount of money. I think for it was over 298 million US dollars, if I can recall. Nigeria down here, had it not been the internal underworkings, which I'm now getting to learn now, they also had a huge bill. I think it was over 70 million US dollars, thereabout. Here in your complaint, we don't see a fine. Well, would you want to give us your opinion? Because we are doing checks and balances for these big techs. In your opinion, I don't know whether you are prejudiced. I don't know whether you, in one way or another, you're not supposed to have that conversation. But you'd give us just an overview. What your opinion is, what the regulators in an African perspective should be doing in light of what is happening globally. Because we are checking these big techs to ensure that they adhere to the basic standards. Over to you.
Thank you so much for that question, Tony. It points to two things. I talked about the big tech kind of lobbying because when I look at the decision, I read it, and it could tell from the wording of the regulator that at some point they were quite afraid to be bold, like how Nigeria was, because of the reasons that I am not afraid to say that we also even have information that Meta funds some of the projects that they do handle. So that points to the lobbying issue that I told you. That yes, much as the law is there, but the regulators at some point, because of the big tech lobbying, they are quite hesitant to go hard on them. Much as they did, they made pronouncements, but in a legal perspective or for a strong enforcement institution, yes, you can do the pronouncements, but now the question I can ask is that the decision itself did not cause that sort of controversy. It did not. I am very sure that even Meta at some point felt like, this is usual. They are used to the
hardcore punches,
So you cannot say that someone has violated data of over 10 million users in your country, and then you move forward by giving them deadlines on how they can comply. I even lost track. I even don't know whether they did or not. But at a certain point, it points out to the question about how the law that we have is structured, which is similar to the rest of the laws around the African continent. That when you look at the act itself and the regulations, the regulator is not given so much power to, penalize Meta the same way it happened in Nigeria. So that points to our law, because much as big tech is lobbying, but it is also using your same law to, come up with ways of how they can navigate the fines. Because for these companies, and the reason why strong regulators around the world penalize them is that they need to cause that sort of financial pain to them, that you need to be penalized so that you can stop. But now, if you just come up with pronouncements, it doesn't make sense for the conversation about big tech accountability and also pushing it forward. So the issue about the decision, I'm not afraid to talk about it. But I do believe that even right now, we have other different avenues that we can use to get money from Meta, because I do believe that if this case is pushed in line with human rights enforcement, we use the same decision because the pronouncements are clear. You wrongly transfer data, you just link that up, you do a class action. Everyone here, swears an affidavit. We go, they quantify, you get some money and go home. But that's because you cannot say that you're going to get affidavits for over
10 million users
for you to get the amount of money that you want. So it might be a section of people like us who say, no, we want our money. Then they give us the money, we share. But our judicial system still, Meta can appeal, you go up to Supreme Court, nothing. So the issue is about how the laws are structured, and why we need these conversations for the rest of the continent is that the challenges that Uganda is facing are the same challenges that we are going to see in the rest of the other jurisdictions. So the issue is about benchmark from how the law is structured in Nigeria, structure your law the same way, or amend, or come up with different policies so that you can hold them accountable. But now we also have the challenge of the lobbying issue by the big tech. They will be observing. They can get to know that Uganda is trying to, change a little bit their law. They come, they say, Mr. Baker, we are giving you 60 billion for promoting data privacy in the sector, for maybe health sector, and our regulators are highly, highly compromised together with the government. So these issues, there is a lot to be done. Much as we look at the EU, but we also need to look at our laws, understand the realities of how these big tech operate, and then we see how we can push these conversations forward. Because the kinds of defenses that they put forward are always silly. To the extent that someone can say that we are not subject to your laws because we do not have presence there, because we are compliant elsewhere where we are registered. Now, to put it in a normal understanding, if, let's say, the United States has a base which is manufacturing ammunitions, missiles, intercontinental ballistic missiles, and then it wakes up in one day and then it shoots Uganda. And then they say, no. Your laws are your laws. For us, we are compliant, we are designated here, everything is okay, we pay taxes, UN comes and observes everything. So everything is purely fine. So we can fire you, people die, and then we say, it's the same thing here. You have data centers the other side, you're extracting the data, you're generating money out of it. And at the same time, we do have the laws here, which require you to register, which even have clear provisions about adequacy standards, which you're violating. So purely, those arguments can't stand. But because of the other lobbying issue that I told you about, that's why we saw that decision that way.
Wow. Ladies and gentlemen, you are listening to Lego Tech Dialogues. Like I said, we are joined with Priscilla Naiga, fintech expert, mergers and acquisitions expert, and the celebrated competition lawyer in Africa, the ambassador for the University Center of Innovation and Policy on Competition Law, Mr. Aziz Kitaka. Aziz Kitaka not long ago was nominated for an innovation award in South Africa. I think he was the second runner-up. That's how far Aziz goes. And he has a number of wins in the area of competition law to his name. I want now to roll this over to Rhoda. She seems to be having burning questions for the panelists. Over to you, Rhoda.
My question goes to Priscilla. As an expert in this sector, we've seen the big players, the small players, but if at all this video pops up on a Ugandan regulator, or if a Ugandan regulator is out there watching this particular podcast, what would you advise them to take as the next step in this sector?
Thank you so much, Rhoda. That's a very good question. And it speaks to the initiatives that Aziz and I have been taking or will be taking this month, a conference and a training. I think a regulator at this moment needs capacity building such that when the need arises, both the people that they regulate and the regulators themselves are able to understand the extent of the laws or the nature of the laws that they are enforcing. And that is why we are having a competition law compliance training. We are not looking at only fintech service providers. We are looking at the regulator. We are looking at compliance officers, legal officers who are interested in this market, the whole range of professionals. So for a regulator, I would say institutional capacity building. So when the need arises, they are actually ready, but it should not be one-sided. Even as a regulator, I think you have a responsibility to create awareness among the people that you're regulating about these laws. And that is why we are having the training that we are having tomorrow. And we hope to have many more in the future. Yes. Over to you, Rhoda.
Wow, thank you very much, Rhoda and Priscilla. We are more than halfway our conversation. We normally want to keep this conversation 1 hour. And we also want to keep within the essence of this conversation. The essence of this conversation is to project to the world out there that there is something in the cooking by Priscilla Naiga and Aziz. So before we look at our wind-up, patch-up questions, I want to throw this to Aziz. Unfortunately, you have answered most of my questions along the way, which is a good thing. But there is this one area which I would want you to look at, Aziz. When you look at take a case of the Nigeria appeal process, investigation, which took, all those so many months. There are so many people would want to be like Aziz. They feel that I think there is need for us to push this narrative. But when they look at the month, the time it takes for you to get a response, the investigation for facts that are all over digital. But an investigation takes 38 months. For starters, one, from where you sit, from your experience who has handled these suits, what are your recommendations? Number two, when you look at the Ugandan perspective, what do you think needs to be done in terms of investigation? Maybe your case was at a quick turnaround time. You could also tell us that, and we applaud our data protection office here. But if there are changes, as a person who is fighting for people to adhere to the rules, you'd also talk to us. These conversations are listened to by the regulators and so many other people. Over to you.
Thank you so much. The reason the issue about the prolonged periods for investigating these complaints is that the regulators need to tick a lot of boxes before they move on to penalize, or before they move on to have the different entities which are engaging in anti-competitive practices to be held accountable. But now, the unique thing about the particular issue about the Meta case that was handled in Nigeria is that, like I said before, these are new markets. Nigeria was faced with two issues, because they're having a data privacy element in the complaint, they're also having a competition element. So what they did that can be benchmarked by maybe the rest of the entities, sorry, the regulators in Africa, is that Nigeria took a wise step to merge the investigation. The Data Privacy Authority came up with a joint investigation with the Competition Authority, which is FCCP, and they moved forward with doing the investigation jointly. Because if you have economists this side, you're investigating an element which has data privacy, whereby the merger which was between Meta and Facebook at some point had deficiencies which had effects with data privacy. Now you lack the mandate as the competition regulator. So you cannot. If you do, then Bowmans will come after you and say that, no, you didn't have the mandate. So for them, what they did was to merge the investigation, and the investigation took that long because of the issues that we are trying to resolve now that these markets are new. Now, even EU itself takes quite a number, quite a number of days and months to come up with a final kind of position. And competition law or competition investigations are structured in such a way that they are not like court, that you file, you plead, a decision is given. For competition, even before the decision is given, you have the hurdle to prove to the regulator that you indeed have a prima facie case. So that means that they need to investigate your prima facie submissions. Then after, they say, okay, you have a case, but we are not yet so sure that indeed there is a violation. So let's give it a benefit of doubt. You've won the prima facie case. Okay, now let's publish that. We are kicking off the investigation. So you can just imagine that just for a regulator to say that you have a prima facie case, it can take them months. Because you've reported, they have to look at everything. Then they say, okay, now this meets the threshold of the investigation. Then thereafter, they say, we have kick-started the investigation, meaning that they have not said that you are at fault, but they're saying that we have just started the investigation. So you count off that time, then they start the investigation, which takes time. And for complaints which have a cross-border effect, the regulator has a burden of having to check every kind of, the 21 countries within COMESA. COMESA cannot just sit there and presume that Meta is violating its dominance in Uganda. So it has to send its representatives who are coming to Uganda on Tuesday. Then they call all stakeholders who are doing business in line with AI chatbots. They ask, are you having any challenge with this? Now a typical Ugandan comes and says that, I am even just dreaming of having a platform on WhatsApp. You get?
Yeah.
So they just look at that and say, no, in Uganda, we found none having a platform on. So the challenge right now comes in that even the platforms which are trying to fight Meta are even not within Africa, but they have presence in Africa. So yes, much as they're just fulfilling their regulatory role. So it's going to take time. Today they are in Uganda, tomorrow they will be in Kenya. So they need to come up with a report and say that we moved around all the 21 countries and we came up with a decision that indeed Meta is violating its dominance. So this takes time, a lot of time. That's for complaints which have a cross-border effect. But for those ones which are national in nature, for example, the ones that may be filed at the Ministry of Trade, there are several issues which come about, issues concerning expertise, the nature of the complaint. We have a fresh kind of committee at the Ministry of Trade. Now, giving them a complaint like the one from Meta, you know, they will collapse, they will make errors, they will because they have even failed to resolve a dispute between self-board and Paras, and now you're giving them a dispute like Meta. So that means they have to go to their, you know, the big regulators like COMESA. They say, you know, can you guide us on this? They're not going to give you a decision. So even for entities and for businesses out there which are facing anti-competitive practices in other digital markets, be it fintech, when you're filing, you have to look at the capacity of the regulator. If you need an interim measure, you look at the law. Yes, the Ugandan law, yes, much as it has the structure for competition, but there are no provisions for getting interim, you know, kind of measures. Because to the extent that even COMESA has just come up with a provision for interim measures, which you also tested during our complaint. But as I said, the capacity, they said that it could not meet the threshold. I do understand that maybe they didn't want to open the floodgates of people coming with so many complaints and saying that we need interim measures. Yeah. So the issue about time depends, would I say, with strategy from the parties which intend to file the competition complaint. If you look at your regulator, you see that the regulator might not be in position to investigate this kind of complaint, but it has a cross-border element. What you need to do is to look out to a regulator which has capacity. Then that means that you're trying to, you know, reduce the time that can be taken to investigate the complaint. So the issue about time, I cannot say that the regulators are at fault. They need to do their work. But now the question is you, the person, you, the entity which is trying to come up with a complaint, what do you need to do? If you see that in the fintech sector, you're seeing that they're having issues concerning digital, you know, these cards, MasterCard and so on, how you say that, you know, we are cheaper cash, we are having these challenges, let's go to the Minister of Trade. You're finding the other Indian is fresh, does not know anything. How you give the guy the complaint, looks at it. They call Mr. Galandi, being a lawyer in tech, they call who. Mr. Galandi is also looking at it saying, oh, let me call my friend in the Oxford. You get? So it's going to take time. But if you find it at COMESA, you're very sure they have different stakeholders. They'll give you a decision. So if you want the dispute to be resolved, have a strategy. Where should I file? Have, you know, a checklist of the strengths of the regulators. I have COMESA. If I'm not going to COMESA, I can go to the East African Competition Authority. They have the capacity. You look at their previous decisions. You go on their website, you're seeing that their latest, their laws are not even 2 years old. And now you're giving them a burden. So it also falls on the other side of the practitioners and the businesses. If they need the resolution of these disputes or investigations to be concluded, and it's about strategy for the regulator, we have nothing to do. They need to do their work. Maybe for the governments, or the discussion that we can have right now is how can we put them in a position whereby they are capable of handling the different kinds of complaints, whereby they have the capacity, they have the expertise. So that's an issue of, you know, should I say policy? And it's just about how you come up with the regulator kind of body and the entity itself. I am hearing so much discussions about how the appointment of the committee for Ministry of Trade is being done. They are calling someone from PSFU, they are calling someone from FITSPA, but the slots are limited. You get? So if you have that kind of situation, then why don't you just, why they not come up with so many committees on different things which can support the central committee together with the secretariat? So it's about the structure. That's why Nigeria is far, because for them, they have tried to come up with structures and systems which touch different kinds of the different markets. If that complaint, I assure you, if it was filed in Uganda, we wouldn't be having a decision now. Or we would be having a decision which would be erroneous. Because Mr. Baker would say, okay, let me handle. And then Bowman comes and says, but it had competition elements and you didn't have a regulator then. So a lot has to be done in line with that.
Wow. Well, this puts in place, a clerical critique, I would say. There are policy issues that need to be addressed. And I think for me, you come out vocal. Sometimes we really do not want to scratch the wound. We feel we should just put salt there. And from a structure perspective, the other day somebody was cracking a joke and he was sharing with me the committee of parliament on ICT. And the equivalent of my grandfather, Moses Ali, that time was part of the committee. So, so you can imagine if we are having that kind of structural arrangements, it becomes a problem. Ladies and gentlemen, we are time spent. I want to remind you that the Big Tech Accountability Summit, which is being organized by AdLego, it's going to be taking place 30th to 31st of July. And online, 200,000. And physical, you want to be there at the hotel. He's yet to tell us the hotel. It'll be 500,000. We still have a bit of time. We can make those collections and be there. Why is this important, in my opinion? Number one, it's an area of practice, and Lego Tech Dialogues is here to open opportunities in line with digital transformation for lawyers. You need to know what's going on before you think you're going to represent fintechs. You need to go what's going on before you think you're going to take on Meta, you're going to take on all these big techs, yeah? So it is important you attend. But also, tomorrow, 8 a.m., there's a new link that has been shared by my boss here, Priscilla Naiga, yeah, on how you can log in. Competition law training for fintechs, yeah. Get log in, get to understand what's taking place in the industry. It's important. If you are a young lawyer, I have my friend Nabende Ezekiel, he follows these conversations. I have my friend Peter Namugera, I'm not surprised sometimes when we have conversations of this nature, we do not have very many people tuning in. Because these are new areas of practice and people want comfort zones. When I say I'm going to host the Commission on Land Registration, who is going to speak the obvious things? I will have so many people tuning in. So the few, I think, like my pastor friend, Priscilla, you are the chosen generation, those who are able to come in and listen to these conversations about these areas of practice. And without really monopolizing the microphone, let me ask my co-moderator, Rhoda, do you have any more questions for Priscilla? Not really. Okay, and I think since Rhoda has decided to keep the best for the last, maybe for tomorrow, never mind, she has been bribed by Priscilla not to dilute their conversation tomorrow. I want to pose this question, which normally flies out to every panelist we host here. And I think I'll start with you, Aziz. Aziz, you have carved, I can say you have carved a niche in competition law. And I have been in spaces outside this country, and your name has popped up. And there are so many people out there, people who are passionate about digital law practice, who say, I wish I can be like Aziz. I wish I can be better than Aziz. I wish I can understand this thing. So my question is, if somebody is going to take your lane, what are those tick-offs? I want to become Aziz. I want to become better than Aziz. I am passionate about what Aziz does. since you came here, you waived your rights. So the knowledge is democratized. Share with us your trade secrets, sir.
So that's a very, very difficult question to answer.
I hope not.
Yes, yes, but yes, I'll respond. The issue about legal practice, and we've been sharing this with you before this conversation. The issue about legal practice or doing business for legal practice is very hard in Uganda and even the rest of the world. It is so competitive, and you're competing with people who are very wise and intelligent, and people who have got, you know, different kinds of credentials and education in these areas. So for me, I feel it's not about hard work. It's about strategy. It's about discovering your passion. Yeah. It's about breaking the norms. And with this, I communicate to the young lawyers, yeah, that much as we have the traditional areas of practice, there is no way you wake up in the morning and say that I'm going to handle a transaction which Mr. Garland is handling, which is over 6 billion. It's impossible. You will wait. You don't know what he has gone through to reach that kind of level. You cannot say that you're going to have Stanbic Bank advising it on tech-related issues when Mr. Garland has been in the space for some time. So you need to strategize. You need to look at things. You need to know the reality on the table that, you know, yes, much as I'm weak, but I'm not weak. I can push forward. I can do what Mr. Garland does, but that is his area. Let me identify us, because there are so many areas under the law where everyone can have a space, they can practice, and they can thrive. Now, mine is not that. It's just about strategy. Yeah. You look at an area which is emerging. You know, different people are reading about this, but you just strategize that competition is wide, but there is this kind of competition, which is digital competition, which is emerging. If I litigate a case on this, then it will have an influence on the entire continent. Having an influence on the entire continent means that I'm generating contacts for the relevant people who are also interested in this. So that's how you earn knowledge. That's how you earn networks. It's about strategy and believing in yourself. Nothing much. You will not go get all the cases in this firm. Mr. Garani has like 400 files. You put them on the table. You say, "Mwena muvewo, so Kimbala gay." You go to court every day. You can break.
Yeah.
And Mr. David Kagwa is one of the people that I learned the strategy about, you know, realizing an area and then you concentrate on that. And for him, there is this Luganda saying that he says that there are so many beans. There are these red beans and then there are those, you know, white beans. Don't be the number, be the what? The yellow one. Because when someone is speaking, we say, no, now, all lawyers are number, so you need to become that, you know, that sort of, that golden bean, yeah, that can be seen, that can be identified, that can create impact. But all that comes with strategy, because if you decide to become the number, you will not be seen. And there are those big numbers like Mr. Garani that someone will say, I need this one. Some sort of, worms. So the issue is about strategy and believing in yourself and breaking the norms. I'm this kind of person who respects senior lawyers, but I respect them in the capacity that they are. But if I say that now this is my space, you are a young lawyer like me, let us battle in the field of competition until we reach the finishing line.
Wow. Wow. So powerful. The only time Aziz Chitaka will wait for you is in his space. It does not matter how long you have practiced. He knows that when it comes to competition law, it's an emerging area of practice. You are actually also a baby in his presence, so he will take you on. Thank you. I think you clearly put it out to the young lawyer. Find a space that is not crowded, a space that you are passionate about, and give it your all, and you'll become better than Aziz. And the issue of senior lawyer, younger lawyer will not arise, because the senior lawyer who is so good on banking, he has 10 supreme cases on his head, will not compete with you. I think that's, for me, a take home. And why I clarify this and why I punch this harder is because when you look at our space, most of the people who follow these conversations are young lawyers, and we are grooming a generation of new lawyers. So I think, thank you very, very much, Aziz. I'll just pick one line. I was having a conversation before I started. I decided to go into digital legal space. And so somebody told me, says, so Tony, now, you think you are going, Masembe is my friend, so he will not mind me quoting him, says, so you think you're going to compete with the founding partner of Max, Mr. Masembe, on banking, when he has over 10 Supreme Court decisions on his head? Tell me how you're going to compete. The question is, the only one who will compete with the Masembe is if I'm going to a bank. If I'm going to Stanbic Bank, I'm saying, look here, Masembe is going to advise you on mortgages. He has Supreme Court decisions on his head. I am going to advise you on your flex pay, because maybe Masembe does not even have a TikTok account. Does not even not know what his view was. Yeah,
That be cut out and shared. What Mr. Masembe?
So now, and yet, the people who are actually wiring this money are people with TikTok accounts, people with Instagram. Yeah. So people who understand what is an algorithm. So I think, for me, I want to just amplify the voice of our distinguished panelist, Mr. Aziz, that as young lawyers, find that niche and hold on it dear, like your life depends on it. Yeah, my friend Rhoda, I don't know if you want to pose this to Priscilla or I should. Good. So Rhoda has given me permission to shoot. Priscilla, you have positioned yourself as a go-to advisor to fintechs. You have published a lot on fintechs, on compliance. You've equally advised greatly on mergers and acquisitions. Many lawyers out there who probably came up to practice during your time have not made these very big strides. And they see Priscilla and say, Chikola Atia, since you decided to waive your rights by coming here, please feel free to share with us what a young lawyer, in your opinion and in your experience, ought to do to break even in this very crowded space that produces almost 2,000 lawyers every year.
Thank you so much, Mr. Galandi. So I am reminded of the words of Mr. Samuel Watasa. We hosted him here sometime on the Legal Tech Dialogues.
Oh, sure, yes.
And he mentioned that the interesting thing about competition law, digital markets, fintech, the interesting thing about those markets, unlike other legal markets, is that everyone is a young lawyer. It does not matter the age. So when we talk about a young lawyer in this area, we do not mean a young lawyer in age.
Yeah.
We mean a young lawyer in practice. And like my colleague Aziz has explained, this being an emerging area, you find that we are all young lawyers. It does not matter how long you've practiced.
Yeah.
It does not matter how long you've lived. The fact remains that we are all young lawyers in this space. So my interest in this area came about as a result of joining the firm last year. And I think Diamond Advocates, and I do not know what happens in other firms, But I think Diamond Advocates is the place where the farm nurtures your dream, and it nurtures an area that is not crowded. I picked interest in this area because I found that it is emerging, and like my colleague Aziz has explained, the beans, the green beans, the white beans, I sat down and asked myself, is there any way I could position myself in such a way that I'm not finding myself in a very crowded market, and looking at the emerging areas, I realized there was fintech. And so I would like to also caution the public. I'm not necessarily an expert, like I said. If you really, really want to know who the experts are, please come for our training tomorrow. Those are the real experts. I am no expert in this area, and that is why we chose a very good lineup of trainers. So in this area, I am equally a young lawyer in age and in practice.
With the edge bit of it, I will take it, but in practice, I will tell you she's not a young lawyer. Ladies and gentlemen, they say that waliwo mumanyi waliwo. So she's picking that leaf that beyond the most knowledgeable, there is another most knowledgeable. I can attest and confirm honestly that I think for me, my age and also my bit of experience, Priscilla is one person you'll go to if you want fintech advice. She researches a lot, she's exposed, she has engaged with a number of these other, but characteristics of her of flying around a humble leaf. That's Priscilla for you. Ladies and gentlemen, thank you very, very much for joining us today. We really can't go beyond this. We were blessed with these distinguished people, and for the people who have joined in today, thank you very, very much. And Mr. Aziz, I know you're a very busy man. We thank you for finding time to come and tell us about the Big Tech Accountability Summit. And for Priscilla, thank you for holding the candle very high up in the sky and for democratizing knowledge. I know that you have gone out of your way to have these big experts, people with PhDs in competition law. It's not a simple leap to bring. Dr. Vela, distinguished in Germany and Kenya, Kenya born and advising across the globe. You are having Ryan Hathwas from South Africa, big exposure, big companies, both fintechs and others. Then you are having Imburu, the Kenya Competition Authority, published a lot. So I think for me, then you have Dr. Anthea, yeah. So your team is solid, and we are looking forward and excited to listen to them tomorrow. Ladies and gentlemen, I just want to wind this up and wish you a good night and call upon everybody. If you have not yet registered for the fintech training tomorrow, go on our socials. The links are there. There is actually a new link. If you're a lawyer, check your email. Uganda Law Society has sent an email together with a Zoom link. For the big summit, go to their socials, add Lego. The summit is on 30th, 31st July, 2 weeks from now. It's going to be a big thing. Guys who understand this shit are going to split it. Let me wish everybody a good night, and may the good Lord bless you. Thank you very much.